Hello, I am Brian from Seoul Law Group, and we are an English-speaking law firm based in Seoul, South Korea. We're back with another law video, and today we'll cover a deportation case study. Deportation laws in South Korea plays a major role in the country's national security and often stir up large debates among policymakers, human rights activists, and the general public. As more international folks turn their eyes to Korea as a future home, understanding the intricacies of deportation law is incredibly important. This video will shed light on what deportation means in the context of South Korea, while simultaneously looking into a deportation overruling case study. If you or someone you know is currently undergoing a deportation case in South Korea, it is essential to hire a lawyer you can trust. What is deportation in Korea? First, it is important to define the term deportation and what it means in the context of Korean law. Like in most countries, deportation occurs when a country's government orders the removal of a foreign national or non-citizen from its borders. This typically occurs if the foreigner has broken the law, submitted fraudulent information to the immigration office, or poses a threat to national security. Deportation is oftentimes not immediate and typically involves a legal process that may include hearings at an immigration office. Therefore, the foreigner typically has the opportunity to present their case either alone or with the help of a lawyer. If you have the status of permanent residency, you will not be deported. However, even permanent residents can be deported if they are sentenced to more than 5 years in prison or commit serious crimes such as sex crimes or drugs. Deportation is a very serious matter, as foreigners may be banned from entering the country for an extended period of time, and in some cases, permanently. In addition, deportation can result in hefty fines and potential criminal charges. While most people are familiar with the idea of deportation, others may be more familiar with the term departure order. Let us break down how the two terms are different. Departure order versus deportation. Both the terms deportation and departure order are used to remove individuals from a country, but they differ in several ways. First, the purpose of the court's decision differs. Departure orders are issued when a foreigner has violated immigration law or overstayed their visa. It is essentially a notice from the immigration office that they must leave within a specific period and may do so on their own. Deportation, however, is a more forceful action taken to remove someone from a country against their will. Second, the consequences of the two differ greatly. Departure orders may result in the individual being banned from re-entering, but they generally have fewer longer-term consequences than deportation. Deportation can result in not being able to enter the country permanently. Finally, the process between the cases is not the same. Departure orders allow the foreigner to make their own travel arrangements, while deportation requires numerous court cases and, in some cases, detention until arrangements are made for the individual. The most important thing to remember is that deportation laws vary between countries. The specifics of deportation should be discussed thoroughly with an expert lawyer in one's native language, if at all possible. Being forced to leave a country can have extremely negative consequences for someone's life, such as losing a plethora of job opportunities or being separated from loved ones. Deportation overruling case study. Unfortunately, the truth about Korean law is that it is not easy for foreigners to win a case for revocation of a departure order. In South Korea, the immigration office has wide discretion, and the court is typically reluctant to overrule any orders issued by the immigration office. That being said, Saul Law Group has a successfully overruled departure case. That being said, Saul Law Group had successfully overruled departure cases. Let us examine the case details and better understand how the client was able to remain in Korea. The case revolved around a male university student who was living in Korea on a D2 visa. He kissed a woman without her permission, and she pressed charges against him. He was found guilty of indecent act by compulsion and appropriately fined. As he committed a sexual crime, the immigration office declared that he is a person deemed highly likely to engage in any conduct harming the interest or public security of the Republic of Korea, as well as a person deemed highly likely to engage in any conduct disturbing economic or social order, as stipulated in the Immigration Act. The man was issued a departure order. He turned to Saul Law Group, whose expert team of lawyers filed an administrative suit seeking revocation of the order. Saul Law Group immediately understood that the best way to approach the case was to examine previous departure orders that had been revoked. Looking at the reasons why, experienced lawyers will be able to find similarities between previous cases and their current one, thereby increasing the odds of turning the court in their client's favor. In cases where the court revoked a departure order, the reasoning behind it varied. First, there was a case in which the immigration office had never officially stated the reason for the departure order. This violates the Administrative Procedure Act. Thus, the court was forced to declare that the order was illegal and revoke it. Secondly, there have been cases where the reason was not considered strong enough to warrant a departure order. In one case, a foreigner committed taking custody of stolen property by negligence and was fined. The court considered the subsequent departure order too harsh, and the crime was committed by negligence and was not intentional. The accused in the case was married to a Korean, and this was also taken into account. Lastly, cases have been overturned when the departure order was not beneficial for national interests. One case example saw a foreigner who was tested as HIV positive. The immigration office issued a departure order based on this information alone. The court revoked the decisions as AIDS has a low risk of transmission. The plaintiff's family was all in Korea, and to quote the court directly, "From the perspective of preventing the spread of HIV, what is more dangerous is when the infection is not confirmed, rather than the case where the infection is confirmed. If there is widespread perception that people can be deported just because their HIV infection is confirmed, there is a high possibility that potentially infected people will avoid testing, which will have an adverse effect." Taking into account all of the information, Saul Law Group knew that it was best to appeal based on the second and third reasons, as the immigration office did not violate due process. Saul Law Group pleaded that the reasoning behind the departure order was not enough to warrant it, as it was a single instance of what is legally considered a minor assault. The order was deemed too strict a punishment. In addition, the victim had already forgiven the plaintiff, expressing her concerns and disapproval of him being deported. Saul Law Group also pleaded that the departure order was not beneficial for national interests. The client was a student with scholarship invited to study by the Korean government after passing an examination that only he had successfully passed in his native country. He was successful at his university and lived a prosperous life in Korea, and sending him back to his home country would strip away many opportunities for him as well as Korean society that he could actively be a part of. As a result, the court determined to overrule the departure order. As outcomes like this are rare in South Korea, where departure orders are typically not questioned, it goes to show what a strong team of lawyers can do for you. If you or anyone you know is struggling with the departure order, please reach out to Solo Group today for guidance about how to approach the court case. Our multilingual team has decades of combined experience in Korean law and will happily provide you with straightforward information that may just allow you to remain in the country. Well, I hope this video was useful for you. If you have any questions or concerns about deportation in Korea, let us know in the comment section below, and you can find more information on solawgroup.com. Don't forget to like, subscribe to our channel, and turn on the notification bell for more Korean law videos, and we hope to see you next time. Goodbye.